On June 18th, 2024, Governor Newsom announced that there's been a compromise reached to reform the California Private Attorney General's Act, also known as PAGA. This reform has huge implications for California employers. And with me today, I've got McWilliams and Yaron M, both partners at the firm here at Zaller Law Group, to discuss what this PAGA reform means for California employers. And even though we're pretty early in the process, it's just been announced, we haven't actually seen the language of what this deal is yet. There's been some indication of what it's going to look like for California employers and employees for that matter, but what this reform is going to look like. So we wanted to discuss that a bit today, take a few minutes to give a brief overview. As I mentioned, the details still aren't out, all the written details in the bill, but we wanted to discuss it and how it's going to play out for California employers. So I guess briefly we'll start with like how we got here. Generally, PAGA has been with us since 2004. It's got huge penalties for California employers on wage and hour violations, up to $200 per employee per pay period. The average settlement, there's been some studies done on this, is over $1 million per case. And if you've got a couple hundred employees, it adds up pretty quickly for penalties at $200 or even $100, a reduced penalty, $100 per pay period per employee. You get into the millions of dollars pretty easily. So we've had this out in California for a while. And what do you guys think is driving this reform measure?
I think there's a few things, but I think most notably, I imagine from California's taken a hit and has in recent years from employers fleeing the state. It's been very difficult to navigate the complex web of labor and employment laws in California. They're particularly employee friendly. You've got attorney fees provisions with statutes like PAGA, which it's like the tail wagging the dog. And we've seen just an influx of these lawsuits, and it's really taking its toll on employers. And these are claims that are not covered by EPLI or any other insurance. So it's out of the pocket of the business. And so there's a multitude of reasons. And I think ultimately this is, because big picture, I see this as sort of a win for employers. We're still waiting on some of the details, but this is good for employers. And I think this is probably in response to all of the hits that they've taken over the years.
Yeah. Good thought. Ann, any thoughts?
Yeah, and I think also, it's good for employees too. I think that's part of the trigger for some of these reforms is that it's putting more money into the pockets of the employees, where some of those studies that you were talking about are showing that an employee is much better off right now having an individual lawsuit. They recover more and it's a faster result than if they're part of this group lawsuit. So yes, I think it's a lot of combinations, a lot of different motivations for the reform. And I think no matter what side of the aisle you're on, or employee or employer, my understanding is this was an effort, compromise after many months of back and forth. So
yeah, and I think a big driver for the deal was that the group of employer advocates, groups that advocate for employers, California employers, got a ballot initiative to reform, basically repeal PAGA, on the ballot here in November of 2024. And this compromise reached with the governor's office and these organizations representing businesses is to avoid that ballot initiative, that fight. And on both sides, I've heard reports of $250 million. Both sides would have had to raise that kind of money to have that ballot fight and spend the money on that. Yeah. So nobody wanted to spend the money on that. So this compromise was to avoid this initiative. So as part of the deal, we heard there's a deal. The governor announced that yesterday. There's no writing yet, but as part of the deal, it's supposed to be written up into a bill passed by the legislature and signed by the governor. It has to be passed by the legislature by June 27th, and then signed by the governor, and then that ballot initiative is going to come off of the ballot later here in 2024. So it's going to be happening pretty fast. Today's June 19th. So they've got
it's next week.
Short time to put that together. So we'll be monitoring once the bill comes out. We'll be writing about that and probably have another podcast about that too. But really quick, just PAGA. If you guys could help, just give a quick 2-minute overview of PAGA and what it means for employers that don't know about PAGA.
So, PAGA came into effect back in 2004. It was supposedly to address the issue of the lack of resources and funds by the California Labor Commissioner to enforce the labor code. And so the PAGA statute basically deputizes a plaintiff to step into the shoes of the labor commissioner and pursue a claim for penalties for labor code violations on behalf of that employee as well as other employees called aggrieved employees. And effectively, per violation, per employee, per pay period, there are penalties that are assessed. The bulk of the penalties that are assessed, 75% go to the governmental entity, when 25% go to the employee. And then there's provision in the PAGA statute that the attorneys for the plaintiff recover their attorney's fees. So that's kind of high level, the PAGA statute.
So it's incentivizing these plaintiff's attorneys to get a plaintiff that had a labor code violation and file this. It's called a representative claim under California law. Very unique. I don't think any other state currently has a statute like PAGA, but I've heard other states are looking at it now. And then it allows this employee to file a lawsuit on behalf of all other aggrieved employees and recover those penalties, so on a representative basis. So it's kind of like a class action, but it's not. And as PAGA developed, we as defendants started making arguments that we'd make in class actions about manageability, standing issues, and all that. And the California courts have, I think across the board, shot down most of those arguments. They said, no, the manageability is not an issue that the defendant can raise. You know, if you've got all these different employees working at different locations, and it's going to be a hard issue to try on a representative basis. The California Supreme Court said, no, the courts don't have discretion to knock a PAGA case out on those grounds. Also, standing has been very, very broad, where anybody, as long as you had one violation, you could bring these PAGA cases on behalf of employees for violations that you've never suffered yourself. And there was a statute of limitations issue with that too, going back even prior to when you worked there. So it became very broad. And the other big issue driving this is you can't waive PAGA claims in arbitration agreements. Unlike class action claims, where you can waive those under federal law, you can have employees waive the right to bring class actions, but they can still bring PAGA claims. So this deal that we are just learning about, it adjusts the penalties to PAGA. Would one of you guys want to discuss what that looks like?
Well, sure. I think one of probably the most interesting is there appears to be a discussion about, or an agreement on, a cap in penalties, which would be the maximum amount. So currently, you're looking at, and you touched on it before, up to $200 per violation, per employee, per pay period. And it's really broken up. Typically for the initial violation, it's $100. But the statute has it up to $100, and there's discretion for the court to adjust it accordingly. But that's left up to the court, and there's no real guidance. Now it appears that they are going to put a cap on the maximum penalty, which will be something less than that $100, for employers who are proactively taking steps to comply with the labor code before receiving a PAGA notice. And then there's going to be a cap or a maximum penalty on after receiving the notice, employers who are taking steps to comply or make changes to. And I think what we have is, for those taking steps before the notice, they are capping the award at 15% of the applicable penalty. So if we were talking about a $100 penalty, you're now looking at a $15 penalty. For employers who are taking steps to fix it after receiving a PAGA notice, the cap on the award would be 30% of the applicable penalty. And this is the first time we're seeing any sort of cap, and there's not a minimum. So it still allows, or at least until we see the final verbiage, it appears to allow for discretion for the court to keep the penalty low, and now gives a restraint that they can't go higher than these 15% or 30% caps.
So it lowers that ceiling that the defendant would have to argue in litigation, saying, well, look, my potential exposure is basically 30% or 15% of what it used to be. So that's a huge benefit for employers.
Right.
And the risk of litigation is drastically reduced if you can show this kind of good faith compliance issue. Right. We were talking about it before the podcast. How is an employer going to show that, though? What are your thoughts on that?
Oh, I think that employers can show that in a variety of ways, and it's just really good HR practice and policies. Regularly do audits of your timekeeping and payroll system, update your handbooks so that you've got compliant policies, train your employees. All of those things really are at the core of establishing what's reasonable for an employer to do, and that they're taking good faith actions. And I think with this new deal, those good faith actions are going to be rewarded and taken into consideration, reduced penalties. And in addition, hopefully this new deal will make clear that the courts continue to retain that discretion to even lower penalties beyond those reduced amounts.
And if I can add, not just doing regular audits, and I think that's absolutely important. I think it may be, doing internal audits is always good practice, right? But this would be a great opportunity and excellent evidence, as far as I'm concerned, if you were to retain outside counsel or agency, somebody to run an audit. That way you are also relying on the expertise of a consultant or counsel coming in. You've got an invoice and something to evidence that audit was conducted and when. And I think that would be very helpful to show, as opposed to an internal audit, which may be self-serving and oftentimes gets rubber stamped as everything is good, same old, same old.
Yeah. And we work with clients. We've done that before. Even this obviously was known, but it's just good compliance. Right. We've worked with clients auditing sometimes quarterly payroll records, just seeing if there's any weird anomalies showing up to prevent liability before it actually arises. One kicker on that I was just thinking about, though, you need to be careful. If you go out, hire a lawyer to do that audit and they tell you to do something, you need to do it. If you don't do it, then it's going to be evidence of bad faith potentially to increase those penalties, where you've got outside counsel saying, hey, you got to put this policy in place and do this, and you need to then follow through with that. So but it's great. And I think training that you mentioned, Ann, is another key component. Training your employees, training your managers what to do, just being proactive, updating handbooks regularly and all that. That's going to be evidence of establishing that. We're hearing too that the deal is going to reduce the penalties for minor violations, for pay stub violations. If you forgot to put the ink on the name of the employer on the pay stub or misspelled the employer's name, those minor violations, there's going to be reduction on that, and some relief for employers. And also we're hearing too, for employers that were paying weekly, they're going to be put on par with employers that were paying either biweekly or some other manner. So basically the employers that are paying weekly are penalized under PAGA because these penalties are based on per employee per pay period. So if you looked at a year period and they're paying weekly, it's basically double the penalty amount versus an employee who's paying biweekly.
Right. This comes into play when we're talking about a 1-year statute of limitations on PAGA, and you can have two employers with the same violation and the same number of employees, but the one who has paying out on a weekly basis,
arguably benefiting their employees more.
correct, is going to be penalized by paying twice as much the penalty as their neighboring employer who's paying every other week.
Right. Yeah. So that'll be good to see. And then on the flip side, they are putting a new penalty for malicious acts. So if they can show, fraudulent activity, oppressive, malicious activity, it's going to kick up. That penalty is going to go up to $200 per employee per pay period. And then we're hearing also the deal is going to address the stacking of penalties for derivative claims. So typically what the plaintiffs have argued, if there's one violation, it triggers a multitude of violations. If you didn't provide the employee with a meal break, therefore they didn't get paid all their wages, that's a violation. Their pay stubs were wrong as well, that's another violation, and they would stack these penalties up. And it looks like that's going to be addressed too. If you got one violation, you're going to get one penalty. You can't add up these derivative claims. So that will be great. Let me see. It's also giving an employer a right to cure. Were you going to address that?
Yeah, I was going to just quickly touch on that right now there's, under PAGA, there's a very limited set of this ability to cure when you get the notice, and you have a short window of time within which the employer can cure. There's little incentive to do that because it's time consuming. You're conceding issues. You need to pay out, and it was unclear how that's going to benefit you. Big picture. And now it looks like, though, they are expanding what can be cured. And in addition to the other incentives, like capping the penalties for those that are proactive, I think in combination, the expansion of this right to cure, plus the cap on proactivity and attempted compliance, could yield additional significant benefits for the employer.
Yeah, I agree.
And it looks like I read somewhere that they've got a couple of new processes on this right to cure or opportunity cure. Apparently the LWDA is going to have a program where employers with less than 100 employees, they can participate in the program during the court proceeding, and the labor agency is going to determine whether or not if the cure is sufficient. And so that might be a way in which, if you get the blessing of the government entity, it might cut off the lawsuit early. And there's going to be some other new process for large employers where they can request an early conference to attempt to cure the violations itself. And then it also looks like there will be a lower penalty for isolated violations that are remediated quickly, especially those pay stub technical violations that don't result in any harm or injury to an employee. There's some really beneficial elements of this new deal, and one thing is the standing. Now the employee is required to suffer the actual labor code violation, where under the current law, all they have to suffer is just one single violation, and then they could sue on behalf of all the other employees for any and all other types of violation.
Yeah.
So I think we're going to really see that impact on the litigation process itself. I can see, filing motions for summary or partial judgment to limit the scope of the PAGA claim itself. The PAGA representative does not have standing to pursue a claim for unreimbursed expenses, because they only have standing to pursue a claim for overtime or whatever you might have. But I really think that's going to have a substantial impact on litigation. And again, though, we need to see the language of this new deal.
Yeah.
And my first question is, does it apply to current cases, or is it only going to apply to those cases going forward? Big unknown, Darren.
Right. We'll see what the final language is on that. So if you're currently involved in litigation, we'll have to see if this is going to impact your case. Yep. On the flip side, too, they're giving some more teeth to the Department of Industrial Relations. It looks like there'll be additional funding to hire more representatives to help the state enforce the labor code provisions, and maybe help with this compliance mechanism that's being built into the deal. And also that will provide for injunctive relief. The plaintiffs can go and seek injunctive relief as well. They were asking for that before too in current lawsuits, but it's going to give them a little more teeth here to have some proactive measure to have an employer stop doing certain issues and get that kind of relief. But overall, I think it's a good deal for employers. It's going to rein in some of these issues that we've been dealing with on the litigation front and reduce the potential liability of the PAGA lawsuit and open some more defenses for employers overall. So it's a much welcomed deal to come through. Going forward, we've talked about the compliance issue that's going to reduce the penalties as we understand the deal right now. So, audits, being proactive on your policies. Any other recommendations that you guys have, as we see this law being passed that you could see employers doing to take advantage of some of these issues?
I think you hit on the ones that they need to do right, and waiting for the language to actually come out, there may be some additional recommendations and tweaks, including what kind of advice we can provide employers. Right now, there's certain advice that we give on strategy and how to handle and be proactive that keeps in mind how this is playing out in the courts. This could touch on some of that advice, but I want to hold that back until I see the actual language.
Yeah. And the other thought I had, employers should be implementing those arbitration agreements too, especially if you're a large employer, have an arbitration agreement with the class action waivers. And it won't protect you from this PAGA litigation, but if this reform actually takes place and goes through, the PAGA litigation is going to be a lot more manageable, hopefully, with these reforms. So still implement arbitration agreement with class action waiver, be proactive with your policies, audits, updating handbooks, monitoring time records, recording the meal breaks. You don't have to record the rest breaks, but do record the time in and out for the meal breaks. And I think those are the best practices going forward.
Absolutely.
And we're talking about best practices before we end. I'll throw out that I also highly recommend attestations on a regular basis from employees to cover those rest and meal breaks during a given pay period.
Yeah, that's a great point. That shifts the burden back to the employee when the employer has those. So those will be super important to have going forward.
And definitely maintain all those records. Make sure that you've got them for the full statutory period. We recommend going back 4 years for all payroll and timekeeping records. And there's a new law that came into effect this year that you're required to keep personnel files for 4 years. So that's evidence. All of these things are bits and pieces of evidence that can be used as a defense in these PAGA cases. And Anthony, you mentioned, the manageability. There's a piece of this new law that is supposedly coming into effect that talks about manageability, and we need to see that language. And is this new bill now going to allow courts to make early case management orders based on manageability, or do they have to wait until the time of trial, which arguably is the standard right now under the California Supreme Court new case that came down this year, Estrada. But I think that there's lots of a lot of things that are going to be developing because of that, and this is all positive in defense of these cases.
Yep, I agree.
It's a glimmer of hope for employers in California.
Yep, I agree. So stay tuned for any other updates. We'll be publishing information on our blog at the California Employment Law Report.com and do another podcast, I'm sure, on this topic as we learn more. So thanks, Ann. Thanks, Yaron.
Thank you.
Thanks, everybody, for tuning in to the podcast and staying informed. If you want more information or need to contact us, please contact us at zallerlaw.com.